What is the doctrine of Lis Pendens under the Transfer of Property Act, 1882? The concept of Lis Pendens is a legal doctrine embodied in Section 52 of the Transfer of Property Act, 1882, TOPA. It plays a crucial role in property transactions that are subject to legal disputes. Here's an explanation of the doctrine. 1. Meaning of Lis Pendens. The term Lis Pendens is Latin for pending suit. It refers to the principle that the subject matter of a lawsuit should not be transferred to another party during the pendency of the litigation. 2. Principle behind Lis Pendens. The doctrine is based on the maxim, ut lit pendendi nihil innovetur, which means, during pending litigation, nothing new should be introduced. This principle is intended to prevent any changes that could affect the rights of the parties involved in the litigation. 3. Application of the doctrine. Lis Pendens applies to any action or proceeding that is pending in a court of law. It prohibits the transfer of any property under litigation to ensure that the court's decision is not rendered ineffectual by subsequent property transactions. 4. Legal effect. Any transfer of immovable property made during the pendency of a suit or proceeding that affects the property is void against the plaintiff in the suit. This means that even if the property is sold or transferred, the legal rights of the original parties remain unaffected by such transfer. 5. Exceptions to the doctrine. There are certain exceptions to the doctrine of Lis Pendens, such as transfers made in pursuance of a statutory requirement or with the permission of the court. In essence, the doctrine of Lis Pendens serves to maintain the status quo of the property in dispute until the legal matter is resolved, thereby protecting the interests of the parties involved and ensuring that justice is not compromised by external transactions.